Judgment in the appeal Belhaj and Straw and Rahmatullah No. 1 and the Ministry of Defence.
Lord Mance will explain the judgment of the court.
This judgment concerns two appeals by United Kingdom authorities and officials, past or present. In the first case, the respondents, Mr. Belhaj and his wife, Mrs. Budchar, Libyan nationals and opponents of Colonel Gaddafi, allege that MI6 informed the Libyan authorities of their whereabouts in 2004, leading to them being rendered from Kuala Lumpur to Libya against their will. They allege that they were unlawfully detained, first by Malaysian officials in Kuala Lumpur, then by Thai officials and United States agents in Bangkok, that they were then rendered in a United States airplane to Libya, where they were detained and tortured and mistreated. They allege that the United Kingdom arranged, assisted, and encouraged their rendition, as well as conspired in and assisted torture, inhumane, and degrading treatment inflicted on them by the United States and Libyan authorities. In the second case, the respondent, Mr. Rahmatullah, was detained by British forces in Iraq on the 28th of February 2004 as a member of the proscribed organisation Lashkar-e-Taiba. Within a few days, he was transferred into the custody of United States authorities, who then held him without charge for over 10 years in Bagram Air Base, Afghanistan. The present judgment is concerned only with this 10-year period, in respect of which Mr. Rahmatullah claims that British officials combined, assisted, and or encouraged his unlawful detention and mistreatment by the United States authorities. The preceding period of a few days in British custody is the subject of the separate judgment just delivered by Lady Hale, holding that Mr. Rahmatullah's claim relating to those few days' custody is barred by the doctrine of Crown Act of State. The present issues are whether, assuming for present purposes that the allegations made are true, the claims of United Kingdom complicity in unlawful detention and mistreatment overseas by foreign state officials are properly triable in the English courts. The appellants rely on the doctrines of state immunity and or foreign act of state. There has been, in this context, no plea of Crown Act of State. In Belhaj, the High Court held that there was no state immunity, but that the claims were barred as being based on foreign acts of state. The Court of Appeal affirmed the decision on state immunity, but held the doctrine of foreign act of state to be firstly limited to acts occurring within the jurisdiction of the relevant foreign state, and secondly subject to a public policy exception for grave human rights violations. In Rahmatullah, the High Court held that neither doctrine applied. Both cases come before this court on appeal, in the case of Rahmatullah by leapfrog order. The Supreme Court unanimously dismisses the government's appeals. Lord Mance gives the lead judgment, Lord Neuberger a concurring judgment, with which Lord Wilson, Lady Hale and Lord Clark agree. Lord Sumption adds a further concurring judgment, with which Lord Hughes agrees. State immunity is based on the sovereign equality of states and international comity. The appellants submit that state immunity covers, as indirect in pleading, cases where it is integral to a claim against United Kingdom authorities that foreign officials acted contrary to law, and they rely in this connection on the recognition in Article 6 of the 2004 United Nations Convention on Jurisdictional Immunities of States of immunity from proceedings seeking to affect, quote, interests or activities of a state. However, these concepts do not embrace mere reputational disadvantage. The relevant foreign states in the present cases will not be affected in any legal sense by proceedings to which they are not party. The pleas of state immunity therefore fail. As to foreign act of state, Lord Mance identifies three types recognised in current English authority, broadly also reflected in Lord Neuberger's judgment. The first is a rule of private international law, whereby a foreign state's legislation will normally be recognised and treated as valid so far as it affects movables or immovable property within that state's jurisdiction. The second rule, taking without necessarily endorsing Court of Appeal authority, goes no further than to preclude a domestic court from questioning, at least in times of civil disorder, the validity of a foreign state's sovereign act in respect of property within its jurisdiction. Even if this rule were to extend more generally to acts directed against the person, it would, however, be subject to a public policy exception which would permit the allegations of complicity in torture, unlawful detention, and enforced rendition to be pursued in the English courts. The third rule is that a domestic court will treat as non-justiciable, or in other words, will refrain from adjudicating on or questioning certain categories of sovereign act by a foreign state abroad, even if outside the jurisdiction of that state. Whether an issue is non-justiciable under this rule falls to be considered on a case-by-case basis, having regard to the separation of powers and the sovereign nature of activities involved. English law will take into account whether issues of fundamental rights are engaged, including liberty, access to justice, and freedom from torture, as well as potentially the international relations consequences of a court adjudicating on the issues. In this case, the circumstances do not lead to a conclusion that the issues are non-justiciable. Lord Sumption identifies two relevant principles: municipal law act of state, corresponding generally with the first two rules of Lord Mance's framework, and international law act of state, corresponding generally with Lord Mance's third rule. Municipal act of state is confined to acts done within the territory of the relevant foreign state. International law act of state requires the English courts not to adjudicate on the lawfulness of the extraterritorial acts of foreign states in their dealings with other states or the subjects of other states, since these occur on the plane of international law. But the doctrine does not apply simply because the facts incidentally disclose that a state has acted unlawfully, and it is also subject to a public policy exception potentially applicable in cases of violations of jus cogens under international law, fundamental norms from which no derogation is permitted, and of fundamental human rights. The Supreme Court finds it unnecessary in these circumstances to decide whether either the UN Convention Against Torture requires modification of the doctrine of foreign act of state to give a universal civil remedy for torture, or whether Article B of the European Convention on Human Rights precludes reliance on state immunity or foreign act of state. It says no more than that the respondents, Mr. Belhaj and Mrs. Bouchar and Mr. Rahmatullah, would face difficulties on each point. In the result, state immunity is, however, no bar to their claims, and the appellant United Kingdom authorities have not, on the assumed facts, shown any entitlement to rely on the doctrine of foreign act of state. The appeals are therefore dismissed and the cases may proceed to trial.
The court is now adjourned.